Okay, we're going to get started here. It's 9 o'clock, so we can get you in and out of here. Good morning. My name is Vicki Sunnysack. I'm the Code Enforcement Officer for the Village of Westmont. Today is the last of 3 informational meetings regarding the landlord licensing ordinance. Our purpose for today is to go over the application, go over how we're going to do inspections, the appeal process on the license, and some other issues with regard to get you started and to help you out and answer any questions so that you can get your information in on a timely manner. The way we're going to work this is, you can read these. I'm not going to go through them. These are some of the topics that we're going to be covering today. We're going to go through our presentation, and if you can just hold all your questions till we go through the presentation, jot them down, and at the end we're going to have a question and answer period, and we'll try and get all of your questions and answers taken care of at the end of the presentation. If you would, we are videotaping this. This will be on our website. We currently have a videotape on the website now of the first meeting, but you know, as time goes along and we have other meetings, we can add additional information that I think will be helpful to everybody in general. So this today's meeting will be replaced on the web page for you. In the back there is a sign-in sheet. It's on a blue tab of paper. Some of you may have signed one that's white. Please note that that is not the village's. So if you sign that and you do not want your information going to a private party, that's the piece of paper that you signed. So I'm not sure whose piece of paper that is. If you could please raise your hand, because if someone does not want their information going to you, they have the right to withdraw that information, because that was a little misleading there. Okay?
Do they have the right to withdraw the information going to Westmont?
No, no.
No, all I'm saying is I just want you to realize that the sign-in sheet for the village is on a blue pad of paper. Right. If you signed a white one, that was not the village's sign-in sheet. You signed someone else's private, for whatever reason they wanted your private information, okay? Yeah, but now, we're going to get started here.
But if they mistakenly signed the blue sheet, can they go and take it off that one? Because they don't want the information going to the village.
You do not have to sign the sign-in sheet. It's simply to let us know who came in here. And if there are questions that cannot be answered today, we have your information so that we can mail it out to you. We've done it in the last 2 meetings prior to that, okay? All right, if you could also, too, if you have cell phones, if you'd put them on vibrate or turn them off so that we don't, you know, disrupt your neighbor or anything like that, that would be greatly appreciated. Okay, so let's just jump right into this. Let's talk a little bit about the ordinance itself. As you know, we held several public comment forums. The village board did to go over and discuss and take comments from the public regarding this ordinance. We took those comments and a task force was put together, and it consisted of village employees, landlords, and tenants, and we held meetings and tried to put together an ordinance that we felt that would work for the best interest of all parties involved. As a result of that, the village board adopted in August of this year the multifamily licensing ordinance to be effective January 1 of 2010. So that's where we're at to date. How does this apply to me? If you own a multifamily dwelling unit, you have 3 units or more, this ordinance applies to you, okay? And you are one owner. If you have a condo complex and where you have several owners, however, 70% or more of the owners rent those units out, that condo building is subject to this ordinance, all right? Now, there are exceptions to this ordinance. The one is as it relates to Mays Lake Village, as it's and any assisted living facilities as they are mandated by the state of Illinois and the federal government. Okay, so they are exempted from this ordinance. Also, the Chad and Bridge communities, while they are not exempt from this ordinance, they are exempt from the fees because they are state and governmental funded. All right? This does not,
Not right outside the door. They can go.
the reason for this is the state inspects their buildings on an annual basis. They do, however, have to provide us with a copy of that inspection so that we are, we know that their buildings are in compliance, just like you with your buildings, even if you have 3 units, have to be in compliance with the ordinance also. All right, let's go over the application real quick here. Did everybody get a copy? No. There's one in the back. I'm going to put it up on the screen for you so you can follow along. If you don't get one, there's some in the back.
On the website.
George, can you turn on the overhead? In the back.
Vicki mentioned they're on the website also.
Also, these documents are on the website. Later on in the presentation, I'm going to show you how to navigate through our website so that you can access this information. Okay, well, and like I said, they are available currently on the website, and I'll show you how to navigate that, and we can also get you additional copies if you don't have access to the web. Okay, the first section, first let me just tell you that you need to read the ordinance in its entirety. You need to be familiar with it. Today's presentation is not going to cover everything that's in that ordinance. We're just trying to get you through the basics so that you can get your applications filled out and submitted, and give you just an overview of how the program works. So I implore you to get a copy of the ordinance, to read it thoroughly, so that you know what your responsibilities as a landlord is, and then any other requirements that you may be subject to that isn't covered today, okay? In the application itself, the first section is just the building information. We want the address of your rental building. Each application, if you are an owner and you owned 3 different buildings, say in 3 locations of the village, you're going to need 3 separate applications. So we need 1 application per building. We're going to need the address of the rental unit. We're going to need the parcel identification number. This is something that we need, that we're going to use as part of our tracking system that we have, a program. And that allows us to better track your piece of property, because that is a number like a Social Security number, in that it doesn't change, okay? It's always related to your piece of property. You can find that number on a tax bill. You can also find it on a deed if you don't know where to find that number. We will need the name of a complex if your building's in a complex such as Willow, West Willow View, the Ponds, Brook Hills, the Fountains, something like that, okay? We will also need the number of dwellings, units that you have in your building, because that's what your fee is based upon. The next section is regarding the owners. We want a list of all of the owners. Now, this includes corporations, LLCs, Incs, you name it, trusts. If you have these types of situations, we are going to need the names of the people in that trust, in that LLC, in that incorporation. We want names and addresses and phone numbers of all the people of interest for that. And you can attach additional pieces of paper or additional copies to the application if there's not enough room in here. We do not accept P.O. boxes. We want your physical address. Questions have been brought up as to, well, I don't want my home address going out to my tenants. I can tell you right now that we, with the new FOIA information. If someone comes in to FOIA that information, we can and we have already turned down information to give your private home address out to whomever submits that FOIA application. So there were a lot of concerns at some of the other meetings that we had. The next section is a managing agent. Managing agent would be if you live in, say, another state, another country, you don't live in the village, you don't have an office in your complex, you don't live in a neighboring county, you can have a managing agent. You don't have to have a managing agent if you meet those certain requirements. That's where you would fill this information in. Along with the managing agent, we want a written statement from the owner as to what responsibilities you are going to give that managing agent. What are you allowing that managing agent to do? Are you giving them full responsibility of the building? If we have an emergency, are you going to let that managing agent take care of any and all problems? In other words, to what extent can we rely on that managing agent, and to what point do you want us to exactly call the owner? Again, no P.O. boxes. We want physical addresses, names. What's been very helpful in some of the applications that we have received so far is an email address. The good thing about that is any changes or information or questions that come up, as I get phone calls daily, I can shoot out just a group email to everybody and say, you know, we got a question about this, and here's the answer to that, kind of like a frequently asked questions thing. Or if there's meetings coming up, or for whatever reason, or if there's a problem with your application, I can email you immediately, and you don't have to wait for the mail to get that information to you. I had a couple applications, I emailed them directly. They came in, took care of the situation the next day. So it worked out very well. So if you do have email address, it's very helpful, and I think it works out very well. Let's see. The next section is in regards to a janitor. Some people have, and you don't have to have a janitor, but some people have, say, a tenant that lives in their building that takes care of just the general maintenance.
What if, like, you don't have a managing agent? You just put a line through it?
Just put not applicable. You do not have to have a janitor either, okay? Some people have someone on site at all times. They have an agreement with one of their tenants to do the vacuuming or cleaning of the common areas. You know, just taking care of some of the exterior areas, some of the minor stuff. You don't have to have one. If you do, fill in the information. It's the same information as the managing agent and as the owners. And again, we need a written statement attached to the application that tells us exactly what responsibilities you give that janitor. Because that janitor may not have the same responsibilities as the managing agent. You may not want the janitor to have the authority to call the plumber. You may want the managing agent to do that, or you may want yourself to do that. That's the main reason why we want to know what authorities you are giving these people to do the, you know, whatever work is necessary. The next section is with regards to accepting mail, letters, violation letters, citations. If other than your managing agent, there is another person that you were going to allow to accept a service, and just as a hypothetical, say you own a building and you live out of the country, and for whatever reason, and we hope this never happens, we have to serve you with a citation. We want to know their name and address, and are you giving them the authority to accept that service, okay? If it's not applicable, put not applicable in there, and then it will get sent to you as the owner, all right? Other information we need is the name of the company of the fire alarm system in your building. The fire department does have some of this information, but it's always good to have current, up-to-date information for that. Just basically the name of the company, their address, and their phone numbers in case we have any kinds of problems with that. The next section may not apply to a good majority of you, but if you do have an elevator, same thing. We want to know the name of the elevator company and who would call if we have a problem with the elevator, their addresses, their phone numbers, etc. The next section is we want the information. The ordinance is mandating that you have a towing or relocation service for your parking areas. We will also need a copy of the agreement that you have with that towing or relocation service. We want the name of the company and all of their information. We are not going to tow vehicles out of your parking lots. It is your responsibility. And what I mean by towing vehicles is an abandoned vehicle, it's an unlicensed vehicle, one that's sitting there in disrepair, it has flat tires, it's been there for over a month, or it's been there for over a couple of weeks, and it's a problem child, and you want it out of your parking lot. This is the towing service, and I will let Detective Gabrielski, who is my partner on the criminal side, give you an idea of the difference between a towing company and a relocation company. Detective?
Towing service would be someone that you as a landlord would call up and tell them, I want this vehicle towed. You as a landlord would have to pay for that. Relocation service is a contract that you have with the towing service, okay? You pay, I think it's $20 a sign to have them posted. That's all you need to pay. You call them up and you say, this vehicle's on my property, it meets my criteria to have it towed. They tow the vehicle and there's no cost to you. The only cost that you're gonna be putting up front is just for the sign that's mandatory to be posted so they know where they could get their vehicle once it's towed.
This is a liability if you tow the wrong car, right?
Pardon me?
The landlord's liable.
This is your private property. You have the right to have that towed. That's the difference between the relocation company. If it meets the certain criteria and that's your private property, it'd be just like your own private residence. Someone drops an abandoned vehicle on your property, you know, you have the right to do that. And if you have further questions on that, we'll get to that at the end of the program, okay? Some of you have asked, well, where do we find the relocation? All I can say is we cannot recommend companies for liability reasons. Check some of the other complexes. Most of you already have a towing service. If you would go around to some of the other complexes in the village, you'll see the signs posted. Give them a call and check them out, and we will, you can get an idea of some of the companies that do serve the village. And I will get to your question when we're done, okay?
Has to do with this issue.
Yeah, we'll get to all questions when we're done with the presentation. That way we can get through this faster, okay? All right, the affirmation section is basically, you're going to sign the bottom of the application, and basically it says that you're going to, you know, meet all of the requirements of the ordinance. All right, you can read that, and there's obviously, you know, you're not going to perjure yourself, and to the best of your ability, you filled this application out, you know, and you haven't malfeasantly put any bad information on there. So that's basically what that says. One thing that I've noticed on some of the applications that have come in, all of the owners, even in the trust, have to sign the application. So if you have 6 people in your trust, all 6 persons must sign this application, as we need the information for all 6 people in that trust company, okay? The one thing that is missing on some of them is the managing agent or the agent that you are going to allow to accept notice of service must also sign this application, all right? So it kind of, you know, gels together, which I can see where it kind of got you know, misread there. And if other pages are needed or necessary, you can add them as needed. But the managing agent, the person who you're going to allow to take notice of service, and then of course any and all of the owners must sign this application. Now some of you are going to say, well, you know, one of my owners lives in Florida, one of them lives out of the country. That's why we have fax. That's why we have emails. You can email that information to them or fax that piece of paper to them. They can sign it and mail it back to you and then get it into us, okay? Now, if any information on the application changes, you're required to give us that change of information within 7 days, all right? So that we can get this in the system so that if something does happen at your building, we have all of the correct information if we have some kind of emergency so that we can contact the person that, you are giving, either you as the owner or the managing agent or the janitor, so we can at least get a hold of someone. All right, so that takes care of the application. George, if we can go back to the okay, let's talk about fees. There's always fees involved. There is a cost that is associated when we have to do this type of a program. We tried to make this simple. Some communities get very complicated. They charge for common areas. They charge for the building as well as number of dwellings. We tried to make this simple. We came up, the Economic Development Director, Fred Kimball, and I'll let him explain how he came up with this figure, but it's $30 per dwelling unit. So for instance, if you have a building with 6 units, you times that times $30, and that's what your application fee is. It's just as simple as that. When you get your application filled out, you will take your application and the fee and you will submit it to the village clerk's office. They are downstairs right as you walk into the door to the right. It is not the village clerk's responsibility to look over your application to make sure it's complete. It is your responsibility to go through it and make sure that you have all of the required information on that application. If you have a building and there are a couple of complexes with one owner that have more than 100 dwelling units, we have given the provision that you can make 2 payments. You can pay for half of it January 1, and then the remaining 50% of the fee is due on July 1st, okay? It's imperative that you get your application and your fee in because there is a 20% penalty each month that your application, if it's not turned in or if it's not completed, you're going to be charged a penalty. The crime-free lease addendum. During our talks with landlords and tenants, we had in as a provision originally that we were going to make it mandatory that you had a written lease with every single tenant. A lot of landlords did not like this idea. They liked the idea of a verbal lease, which is perfectly fine. We took that out of the ordinance. Please know that even though you don't have a written lease, there is always an assumed verbal lease. The one thing that we all agreed on is that you must have a crime-free lease addendum. This addendum must be signed by each tenant in your dwelling units of the age of 18 years or older. This is a tool for you to use. If there is illegal activity, drug activity, gang activity, for whatever reason, this tool helps you evict those problem tenants a lot quicker than what the normal eviction process is. It is a great tool for you as landlords to use, and we really encourage you to use it. One thing that we would encourage you to do also is, a lot of you may say, well, how do I know if something's going on in one of my dwelling units? You won't. The way to do that is go into the police department and the records, and you can fill out a Freedom of Information form and hand it to the records department. And it's very helpful. If you do it on a monthly basis, you can say, I want to know what calls for service happened at my particular building. And they can give you a list of what they responded to during that month so that you know what's going on in your building. With that, I'm going to have Linda Pazinski, who is a prosecuting attorney, She is a leading expert on code-related issues. She teaches seminars nationwide for the International Code Council. She's written many national publications regarding anything from property maintenance, 5 books, I believe, on building codes and enforcement and legal issues. She's going to just briefly go through some of the tools you can use for the eviction process, okay?
Thank you, Vicki. There's a number of provisions in Illinois state law that many landlords don't know about in terms of being able to evict a troubling tenant, even if they're paying the rent. Because obviously, if you've got people who are committing crimes on your property, it's going to drive away other good tenants. They're just not going to renew their lease. They're going to move. And I've seen this happen again and again in the various towns that I prosecute for. First of all, there's a provision for anyone who commits a Class X felony on your property. And this is why you need the crime-free housing addendum to sign, because in order to use this in forcible entry and detainer court, you have to have a lease addendum for drug-free housing. And so that's why we have required this addendum. It's actually for your benefit, so you can use this particular provision of the law. So if there is a Class X felony committed on the premises, or there's a grand jury indictment, in this county, that's what happens, is they don't do preliminary hearings, they have grand jury indictments, the lease becomes void. By operation of law, the lease is void. You can give them notice to vacate the premises in 5 days. It has to contain the basis on the clerk of the court, a particular form to use to notify them, and then you can bring an action in Forcible Entry and Detainer Act. The person does not forfeit their security deposit, and you can rely on information given to you by the law enforcement agent and the state's attorney when you bring one of these types of evictions. So just be aware that if somebody commits a Class X felony, which is a very, very serious offense, that you can declare the lease void. There is another provision under a separate law in Illinois that says that you can evict someone if cannabis, narcotics, or a controlled substance are found or used anywhere on the premises, and that the substances were used or possessed by a tenant or occupant, or that a tenant or occupant knew or should have reasonably known the substance was used or possessed, can be the basis for an eviction. So if you're having trouble with one of the tenants who live there, who brings friends over, who are involved in drugs and so forth, that can be a basis for you to evict someone from the property. One of the most useful provisions is this provision in the Forcible Entry and Detainer Code, and that is an eviction based on the use of the premises in furtherance of a criminal offense. So if a lessee or occupant on one or more occasions uses or permits the permits the premises to be used for the commission of a Class A misdemeanor or felony in Illinois, the landlord has the option to hold the lease void. A Class A misdemeanor can be a battery. It could be criminal damage to property of a small amount, under $150 worth. It could be any type of reckless conduct or possession of a Class A amount of cannabis. So there's a lot of different kinds of activity that people get involved in that disrupt life in a multifamily housing setting that you can use to get rid of a problem tenant. You may recover possession of the premises from the tenant as if the tenant were holding over after the expiration of a lease. And the tenant doesn't forfeit the security deposit. And what's really nice about this one is the judgment for possession rendered under this provision in court may not be stayed for longer than 7 days unless you agree to it with the tenant. So that's a really powerful tool that you can use to get rid of problem tenants. And again, if you have information from the police department, you can call upon the police department if you issue subpoenas to various witnesses to crimes. You'd be able to prove this up in forcible entry and detainer court. And I think it's an extremely useful tool that landlords should be aware of. Obviously, there's always alternatives to evictions, because sometimes, you know, I understand that there's legal fees involved. I mean, I used to represent landlords when I first went into private practice and did some forcible entry and detainer work, and I know that it does cost money, but in the long run, it's even costlier if your leasing rate plummets because other, you know, good tenants don't want to stay and renew their lease. I used to advise tenants, look, the lease is coming up soon, rather than go through the eviction process, just don't renew it when it comes up. And sometimes we were able to reach I would tell a client, it's going to cost you X dollars to pay me to evict this person. See if they'll take half of it and move out within the next week, because you're saving yourself money if you do that, and you're getting rid of somebody, and maybe you can get somebody in there that's going to be a good paying tenant. So that's a private matter between you and the tenant and your attorney, but keep it in mind. Of course, when you do an eviction, and most of you probably already know this, you have to make sure you use the proper form. You have to make sure that it's filled out properly, that the time that you give the tenant a notice is accurate according to the statute, that you serve it properly. And sometimes it comes down to, you might want to hire an attorney to make sure that it's done correctly. Some of you are very experienced and can handle it yourself. Other people kind of struggle with it. I hear that from the judges in forcible entry and detainer court. And if you're a larger complex, you probably already have an attorney on retainer. You're all familiar with a 5-day notice to quit for non-payment of fine. Some of these statutes that I just mentioned, except for the Class X, require a 10-day notice to quit with the reason why you are invoking that section of the statute to be served, similar to the 5-day notice.
Thank you, Linda. All right, we're going to talk about the inspections. Basically, what we are going to do is we're going to make every attempt with the staff that we have to do an annual inspection of your building. That would include the exterior areas of the building and the interior common areas of the building. We will also conduct a minimum of inspections of a minimum of 10% of the dwelling units in your complex. What we will try to do is get consent, verbal consent, but we're going to make sure that it's in writing. So if we say tenant in unit number 1, we'd like to do an inspection in your unit, make sure it's up to code, we're going to have them sign a written paper. If they can be there for the inspection, we would prefer that. If not, they can give written permission to you as the owner to accompany us to get in there. You may have, we may run across a tenant that says, you know what, Village, you can't enter my dwelling unit. I'm not going to let you in. That's fine. They have that right. That is their constitutional right. We'll go and do some other dwelling units. However, if, you know, say we've done all inspections of all the dwelling units over a number of years, and this one is just still sitting there, we may be forced to get an administrative warrant. And that has been upheld by the U.S. Supreme Court. We can get an administrative warrant, and we can serve that warrant to do our inspection, to do code enforcement inspections only, and that's all that we would be looking. It's not like a search warrant. It's not where we're going to come in, we're going to bust down the door, we're going to toss the place, we're looking for criminal activity. We're in there looking for code violations. Why do we want to inspect dwelling units? It's 2 reasons. One, we obviously want to make sure that the tenant is protected, that, you know, obviously some of the things in there, the smoke detectors work and the CO detectors and other issues like that. The other thing is to protect you. We want to make sure that that tenant hasn't gone in there and trashed your unit. So they are responsible for some of the things that goes on there. So you necessarily you may not necessarily get a violation notice for something inside the unit. We may turn around and send a violation notice to the tenant and say, look, you need to correct this because this is your responsibility as a tenant in that unit. So know that this is kind of twofold. It's not that we're trying to get in there and find all these kinds of crazy things. We're in there to do one purpose, and that is to look for code violations. Let's see. covered the written consent. Inspectors, let's talk about the inspectors. I am an International Code Council certified inspector. I hold about 4 certifications, one of which is through the Property Maintenance Code Inspector. Myself and 2 other employees in my department are currently taking certification tests. Inspectors that do these code enforcement inspections will be certified through the International Code Council. We have to go through training, and we have to take a certification test, which I can tell you is not easy through experience. Upon that certification, we also have to go to training every single year for continuing ed, just like anyone else who requires a certification, like an engineer or whatever. We have to maintain credit education units and to maintain our certification. When we are on the site, we will always have an identification card on us. Looks like this. I don't know if any of you can see it. But if you see someone inspecting your building, ask to see their identification, know who we are. A lot of you know who I am. There's going to be a couple other inspectors out there. If you don't recognize them, ask them who they are. Why are they there? Look for their identification. They'll have that on their person at all times.
Vicki, you want to mention plumbing and electrical inspectors?
Great. We do have licensed plumbing inspector who is part-time with the village, and we do have a full-time electrical inspector who is also a licensed electrician. You may see them on the premises also if we have some other issues regarding electrical or plumbing. So they too, though, will have an identification on them. They have identification cards, okay?
The 7-day notice, Vicki, for...
All right, yes. Prior to us doing inspections of the buildings and the dwelling units, we will give you a written notice as to when, the date that we are going to do the inspection. It will be at least a minimum of 7 days. I can tell you that it will probably be more than a 7-day notice because we are going to have a lot of buildings to inspect, and we're going to have to schedule these well in advance to get through all of the buildings in the village. You may or may not know that based on the last census, approximately 48% of the dwelling units in the village of Westmont are rental units. That's a lot of units, a lot of buildings that we're going to have to inspect. So we're going to have to schedule these inspections, and we'll get that notice out to you. The ordinance says we have to give you a minimum of 7 days, but anticipate that it would be longer. You know, you'll get more notice than that. We always encourage that you accompany us or you have your managing agent accompany us with it. It's a lot easier because some of the codes are a little difficult when you're reading it on a sheet of paper as opposed to me showing you exactly where it's at and what needs to be done and further explanation on that. That's worked out a lot. A lot of the landlords have called me and we've scheduled an appointment and we have went out and met at the site and walked through the building and shown them violations, and it clicked then. They understood what that was, so it helped out tremendously. Let's see what else I got here. Okay, as a part of your application form, the initial inspection and the first re-inspection is covered under your application fee. So when we go out and do our initial inspection, hopefully we'll go through there and we'll find no violations and everything's peachy keen. You'll be compliant and we're done with your building. If we find violations, the next re-inspection, what we'll do is on the initial inspection, we will write you a notice that says these are some deficiencies we've found in your building, and these need to be corrected. We will give you, I believe it's 30 days we give you to make those corrections. If the re-inspection, so I give you the initial violation notice. At the end of that 30 days, we're going to come and do a re-inspection. That re-inspection is also included in your application fee. So if I come back and I look at my list and you have 10 items, and all 10 items are done, we're good. If I come back and those 10 items, you've still got some outstanding issues, that third reinspection that I got to come back to, that's going to cost you $50, okay, per hour, per inspector. So that's why we give you that 30-day window. Now, obviously, there are some things that may need corrected that may take more than 30 days, you know, depending on the extent of the violation. We want to work with you. We're not here to just, you know, take you to court right out of loud. We want to work with you. We want compliance. That's our goal. And we have done that in the past. I think I've covered everything under this. And do know that, you know, it has come down to it. We have gone to court. If you choose to just ignore the violations and you don't get them taken care of, sooner or later you're going to get a citation and we're going to see you in court. That's the last thing we want to do. We've got better things to do than spend a whole day at Downer Grove in court, you know, taking these things to court. That's the last resort, okay? We want compliance.
Did you talk about the appeals process?
Yeah, coming up.
Okay.
All right. With the application, the village, if you read the ordinance, has provisions that if we suspend or revoke your license, you have the right to appeal, okay? That is your legal right to appeal. The appeal must be in writing, and it's on an appeal form that you can obtain from our office. It must be submitted within 30 days. So if for whatever reason your application is suspended or revocated, you have 30 days to get that written notice into the Economic Development Department to file an appeal. What happens then is we will send you a written notice that says, okay, we've received your appeal, and it will be in front of the appeals board on a certain date and time, and it will be held here in this building. The appeals board is made up of 3 members. One is from the village, one is a representative of a landlord, in other words, it is a landlord in the village of Westmont, and the other is, it will be a tenant. It's a tenant from a rental unit in the village of Westmont. They will hear the appeals and they will make a decision. After the hearing, they have 5 business days to make a decision of whether to reject or agree with your appeal, and then that decision will be sent to you by certified mail in the mail through that way. And of course, if you don't like the decision of the appeals process, everybody has the right to go on further, and that would be going through the court system. Okay? All right, we've covered all of the information that I wanted to get through. What I want to do now is take some questions from you on the information that we've covered here: the application, the inspections, the appeal process, in the crime-free lease addendum. So now keep in mind we are being videotaped and we must use a microphone, okay? So if we could keep one person talking at a time, Detective Gabrielski is going to come around with a microphone. So if you raise your hand, we'll take one question at a time, and he'll come to you with the microphone, ask your question, and then of all of us, we'll try and get you an answer to the best of our ability, okay? Yes, ma'am.
Hi. If I, as the owner, wanted to get any citations for my buildings, then do I not fill out the managing agent part or just put not applicable because I want to know everything?
Correct. If you want to be served violation notices or service of notice, yes, just put not applicable.
Okay, thank you.
That depends on whether you need a managing agent or not. If you need a managing agent, because you don't live, you live too far away, then you have to put the information in on the managing agent. I would say that, first of all, it would be our intent to always notify the owners and the managing agent on any notice of violation.
Oh,
Because,
most definitely.
Yeah,
We will
but
give.
it's just for purposes, mainly the managing agent is to make sure that we don't have to go chase absentee landlords. This can be a huge problem elsewhere where you have tenants without heat, the owners in Florida for the winter time, and there's nobody who will take any action. I have run into that repeatedly. And so don't worry about not being in the loop as an owner. You always will be in the loop. The managing agent, though, will also be in the loop if you have a managing agent that you need because of the law.
Right. Jerry Springer, microphone man.
A crime-free addendum, is there a form we use, or do we have to draft our own?
There's a form in the back room here, okay? And also, you know what, why don't I right now just go through the website to show you where some of these forms are if you have access to that.
Give them the website address to start, Vicki.
Okay, our website address is westmont.il.gov, all right? And this is what it looks like when you come onto our website. westmont.il.gov.
G-O-V.
G-O-V. Okay? Now, once you get to the website, I need my glasses. Okay. On the sidebar here on the quick links, you're going to see departments. Okay? You're going to click on departments. And then this page will come up right here. You can either click on the sidebar, economic development, or you can click on the red economic development right there. And then the economic development department page comes up. If you scroll down, you will see on the sidebars underneath code enforcement, multifamily housing program. If you just click on that, it kind of gives you a synopsis of the multifamily housing program. And then this right here is where today's session is going to be so that other people who couldn't make it can view this. And then underneath that, you will see, and this is in PDF form, that the ordinance, the application, the crime-free lease addendum, and right now, the bottom one here, that's the lease addendum again. We're going to be replacing that with the inspection checklist, so if you misplaced that, you can get a hold of that. So that's how you can navigate through our website to get these forms. All right? Let me get out of that, get back to where we're at. Okay, more questions?
Well, just real quick, is that an annual fee? So every year you pay the 30, so 100?
Yes, that's an annual fee.
Regarding the crime-free addendum, I received a two-part form that addresses this from the property manager at the Ponds. Is that the same thing?
Two-part form.
Yeah.
The crime-free lease addendum has 2 pages to it. Is that what you're talking about?
No, it's an NCR form. It's white and yellow that I received from the property manager.
Did they maybe have it printed out?
That be in the fire department inspection report?
Oh, where's your building?
At the Ponds.
Okay, I believe that they had a form typed up themselves so that they can keep a carbon copy in their managing agent. Is that what that is right there? Can I show that? Thank you. Yeah, this form right here?
Right.
Right, this is something that the Ponds put together, probably for reasons that they want their managing agent to have a copy in their office so that they can attach one to the application. It's the same thing,
It's the
yes.
same thing. One other question, this checklist for the inspection form, is that for informational purposes only?
That's for informational purposes only. Basically, that is the items that we are going to be looking at. Now, keep in mind, it's not all-inclusive.
Okay, we don't have to do anything with it as far as filling it out?
No, but you know that your inspection is inevitable. Take that inspection list. It's a guide for you. Go through your building, look through that checklist. And what it does is it gives you an idea of the things we're going to look for, so that gives you an opportunity to take care of any problems, if you have them at all, before we get there. So that's why I wanted you to have that. Yes, sir.
I have two questions. One's on the parking. It says, any motor vehicle or other vehicle that has not been moved or used for 7 consecutive days. I have tenants that cruise and are gone for 3 weeks or so.
That would be between you and your tenant. If there's that happens. The 7 days came from the state law. The definition of an abandoned vehicle through the state statute is a vehicle that hasn't been moved for more than 7 days. But if that tenant comes to you and says, Mr. Landlord, I'm going to be, some of them are snowbirds that go down to Florida.
But is that relevant? Do I have to tow them?
No, sir.
According to the
It's
law,
totally
7
up to you. If it's got a proper plate, it's not in disrepair, and you know about it, then you don't have to tow it.
Okay. My second question, is the fire inspection the same as this crime fee? So there's 2 inspections per year?
Right. The Fire Prevention Bureau has their own criteria, and they have their own inspections. We're going to try, I believe, to coordinate our efforts to minimize, the number of inspections that you have.
Okay.
Right, Doug?
Mm-hmm.
Yes, sir.
I, as a tenant, feel that this ordinance and its provisions violate my rights to privacy, my civil rights, and in my opinion, this is unconstitutional. We already have building codes, code enforcers, law enforcement in this town. We don't need another ordinance. What this is really about is that we have estimated over 5,000 units in Westmont, and at $30 a unit, that's what this is really all about. There's nothing new in this ordinance that we haven't already on the books. I refuse.
What's your
I'm gonna
question,
refuse
sir? What's your
to take
question?
part in this.
All right, then you'll be prosecuted for renting without a license.
And I will file a lawsuit if I'm evicted,
Okay.
because I refuse.
That's fine. That's fine, because the ordinances like this.
You people
Sir,
object, but
sir,
you don't
do you
take it.
have a question? Do you have a question, sir?
I'll find out when I go to court.
Okay. Let me just address, I know there.
Have you considered?
Can you sit
Sir,
down?
would you please sit down?
Thank you.
Sir, I will address the constitutionality of the ordinance. These ordinances, these rental inspection ordinances, have been upheld as constitutional throughout the country in various states, Ohio, Missouri, among others. All right. They have, Camara versus San Francisco has been upheld by the United States Supreme Court, which is the law of the land, which says that if we are not allowed into a premises, we can only go in with an administrative search warrant. If necessary, we will do that. That is what the city of Peoria did when they initially passed their ordinance and were challenged on the basis that it was unconstitutional, and the case was thrown out against the landlords by the district court there and was upheld by the appellate court. The purpose for this ordinance, the only reason that this ordinance goes into effect, the only reason that these ordinances have gone into effect is basically what it starts out is that there's a crime problem in town. And what we have found across the country through research is that these type of ordinances reduce crime in apartment building complexes. It makes for better tenants. It increases property values. And what I can tell you my experience in Woodridge, because I've been prosecuting for them for over 20 years, and we've had a landlord licensing ordinance in Woodridge for most of that time, is that I can tell you how many cases that I have prosecuted in the last year against landlords in Woodridge, and that's a pretty large apartment complex. I could count them on one hand. Most of those charges are for not getting their license renewed on time because, quite frankly, the condition of the property is excellent. Usually the kinds of things we find are inoperable smoke detectors. And what we have are landlords who come back and tell us, you know, I was really against this to begin with, but you know what? It has forced other landlords to step up their game and spend the money that I'm already spending because I'm a good landlord. And it's leveled the playing field because you're able to charge rents that are commensurate with the quality of the building that you're in, and you're not being undercut by people who aren't doing the same thing. The tenants, for the most part, really, really like it because they don't have to worry about retaliation if something is found in their unit. And I have to tell you, I have prosecuted around this area for a long time, and I have had roach-infested units. I have had unsanitary units. I have had boarded-up exits where people couldn't get out in a fire. Unfortunately, not all of them are the good landlords like you who care enough to come out on a Saturday morning to attend. But that's the way that we keep everybody's property values up. And obviously, people have the right in this country to file a lawsuit if they choose to, but just know going in that this issue has already been decided by a number of courts, both in Illinois and around the country. And just like any other profession that gets regulated and has to be licensed, you're in a business. Businesses are regulated. I have to pay for my license every year. The doctors have to pay for their license. The roofer that does the work on the roof in your building has to pay for their license every year. And it's to maintain minimum standards. We're not trying to turn anybody's property into, you know, the Hyatt Regency or anything. Just minimum standards so people can live in safety. So I appreciate your sentiment. I understand it's out there, but this is constitutional. There is a provision for an administrative search warrant in this statute, which I have drafted many times in other towns. And if you choose not to cooperate with the ordinance, there will be consequences, and we will let the court decide, as the courts have decided, and they rely on precedent, that is, the cases that have been decided by them.
Okay, any other questions regarding the information we covered today? Yes,
Just
sir.
a brief request for all the slides that you showed today. Would you be placing those on the website so that we can have
Sure,
that
I can
information?
talk to the IT director and see if we can get those on there for you. Yes, sir. Yes, ma'am.
Once again, could you tell me what the U.S. Supreme Court case was called? So that
Camara versus San Francisco.
M-A-Y-O-R?
Pardon?
How do you spell mayor?
Camara.
C-A-M-A-R-A. It indicated that an administrative search warrant can be obtained by code inspectors when an owner refuses to allow a safety check.
Okay, we're going to keep this to one person talking at a time and with the microphone. Yes, sir, in the back.
Linda, you're scaring the heck out of me. All this talk about warrants and you got the right, you got the law on your side. You're scaring me so bad, I'm going to go home and have a heart attack. I'm telling you, this almost feels like what Hitler did. I mean, it's scary the way you're talking. That I know you got the force of the law behind you, but we're just guys trying to make a buck.
I have not had to.
You're scaring the heck out of us with that fear-mongering.
Let me explain something. I have not had to issue one administrative search warrant on an apartment building in probably about 15 years. Because you know what? Most people...
You're scaring the heck out of us.
Well, that's personal.
I got it now.
Go ahead.
Okay, now listen, we're going to take questions because there are a lot of people in here who are here to get information on the application and the process itself. So let's keep our questions to the information covered today, please. Okay, Lenny, the lady in the back or wherever? Yes, ma'am.
Yes, upon your inspections, you were saying that all the inspections are covered by the annual fees, correct, and the second time out. You also mentioned an inspection if you were to go into the tenant's unit and say they were destroying the units and it was a violation of the code because they destroyed the unit.
Mm-hmm.
Are we then charged for that, or is the tenant charged for that?
If it's a tenant's responsibility, it will be charged to the tenant.
Oh, okay, that's interesting.
Okay.
Is that in the laws as well, in the ordinance?
Well, ultimately,
Because
as
it will
the
be a
owner,
violation of the code of the building, but it wasn't a violation on our part as a tenant, or as a landlord. So
We're
I'm
going
just
to
kind of
find that on
wondering
the
about-
first inspection.
No, I'm just saying.
And we're going to
that-
give you an opportunity to take your necessary action to do that. And so if it's going to, for example, we've worked with landlords in the past where they have a problem tenant and they said, I've got the eviction process started, we can't do it within 30 days, it's going to take X number of days. And we say, hey, we'll work with you, no problem. Because if you're taking
Because
steps to
sometimes that
remove that
takes
tenant
3
because you,
months or more.
I
Right.
understand that it's a longer process. And my
Right.
attitude has always been, we will, first of all, we will charge the tenant with a property maintenance code violation for, let's say that they bring in 6 cats and they let the cats pee all over the rugs and everything, and, you know, really making it a mess, because I've had those kind of situations too. Once we've alerted you to that, then you're going to begin your own process to do what you need to do to rectify the situation. And my experience has been that as long as the landlord is cooperating with the inspector, that we'll do everything possible to support you in that. And we wouldn't, you know, the re-inspection, you guys can negotiate how long that second inspection will be for, and with an idea in mind that that's a reasonable time for you to be able to get that unit into compliance.
Right.
I have not found that that's really been a big problem. It just, usually the landlord has filed the eviction and we just wait, you know, we'll continue the due date until such time as we know that the person's going to be out, because I understand it's a long process.
When there's a couple of owners on a property, you need the information on their addresses and everything else.
Yes, ma'am.
But in this case, like, you know, I'm one of the owners, but I'm not a manager per se, but I'm the only one who takes care of the building. Can I specify that so that, you know, the other owners basically aren't being bothered?
Sure. Well, what you can do is this on? Okay. You're going to list all of the owners in the owner information, okay? And then as an owner, if you want to act, say there's, you know, 5 people in a trust, and only you want one person to do all of be the maiden contact, put that in the managing agent also, so that your name would appear also in the owner section and in the managing agent section.
So I would put that as the managing agent.
Sure.
Owner.
Yes.
Okay, another question now. I just have somebody come into the hallways to clean like twice a month. Is that considered janitorial service?
That would be a private service, like a carpet cleaner that you would call to come in. That would not be considered a janitor, no. Detective Gabrielski's coming around.
Yes, they're charging to $30 per unit. Yes,
sir.
Now I have like studio apartments, or 1 unit. I have 16 of them. It's a 1-bedroom apartment, so I have to pay $30 for each studio apartment. What happens if you have a 2-bedroom or a 3-bedroom?
It's the same all the way around.
Really?
Yes.
Even though it's 1 room?
Yes. We have a next question? Yes, ma'am.
I have a sign, I'm sorry. I have an apartment building with a sign in the back saying it's private parking on my lot, and I have an agreement with the police department that I can call up if there's a car parked there illegally, and they come and ticket it. Now, is that going to change, or?
I'll let Detective Gabrielski answer that one.
We'll still come and ticket it. However, we're not going to tow it. It's going to be your responsibility. We'll still come and ticket it. So just give us a call.
I have a question about the inspection form.
Okay.
And it's a good form. I've done some upgrades to my building, and my question is, are you going to use this guideline all the time, or is this, or will you be changing the emphasis to something else? I don't know.
No, basically that guideline is the property maintenance ordinance. Now, if there's a change in the code, in the property maintenance code, say we adopt a new version of the code and there's code changes, that's where your email addresses come in really handy, because then I can just send out a blanket email that says, hey, by the way, you know, if we come by and your guardrail is bad, they changed, and this is hypothetical, they changed the distance between the balusters or something like that.
Yeah.
So, but basically that checklist is what we're going to be looking for.
Well, that's great. Now, another thing is, I install lights in the, for the parking area. The parking lot, the number of units is below the 10 units, but in total, because both my buildings, the lot itself has like 18 cars, but each one would only have 9. It's less than the required amount for the lighting requirement. I mean, to comply with that particular lighting. But I put the lights in anyway, and my question is, I had the parking lot expanded years ago, and I'm just questioning that, and there was a permit needed to do that, and I'm just wondering if the building code takes into the lighting consideration for something like that. I mean, like per square foot, you need so much lighting because that would cover the number of cars. Because the ordinance says 10 cars, you need a certain amount of lighting. And if the building code for parking lots were to include the some sort of a lighting requirement per square foot, it would automatically take care of this lighting issue,
Okay.
At the time when I had this done, the consideration, there wasn't really any, and there really wasn't a need to consider it, but it would just automatically, provide, means for lighting for this square foot.
I believe you're referring to the illumination requirements that are in the ordinance,
Yeah,
correct?
right.
For some of those that may not have read the ordinance, if you, on page 9, section 5610C has provisions for illumination of your parking areas and common areas. So basically, if you have your lights under that, in accordance with that, you're going to be just fine.
Well, sure. I'm just saying that I'm pointing out the example that if the building code included like like an illumination requirement, necessary for so many square feet, that would cover the number of cars, the illumination per cars, because that's what this is based on. For 10 cars.
If you choose to have more parking spaces than what's required by the building code, is that what you're in reference to, or the zoning ordinance?
No, I'm saying that the building code, if the building code required a certain amount of light for so many square feet, then that's what this ordinance is about, the number of cars, 10 cars, you need, it begins the requirement of lighting.
This ordinance matches the code.
Yeah, well,
They're equal. This ordinance matches the code.
Okay? All right. Detective's coming around. Yes, sir.
2 questions for you. Keep a nice building aesthetically pleasing, safe. The inspections for that, I don't mind the safety aspect of it. 2 questions with the inspections. Was my building, built 30 years ago under different codes that are required now? Just one that might come to mind is like GFCI outlets and bathrooms and kitchens. I don't think I have those. Am I going to be required to replace all of those in every unit? Question number 1. Question number 2 is, on the inspection, I guess, how thorough are you going to be? Some of these seem aesthetic to me. Completely understand the safety, but maybe torn screen doors on the patios. Those tear all the time. And if that's an issue, I'll just get rid of the screen doors. Windows that are clouding up because the seal is gone. I do have a few of those. Can I afford to replace all the windows in my building? Absolutely not. I mean, rent is commensurate with what the tenants are getting. It's a clean, safe building. Are there things on here, you know, nail pops? Well, yeah, it's a 30-year-old building. There's going to be some nail pops.
Let me just address the issue of older codes. When it comes to safety, type things like property maintenance code and the fire code, no matter what the law was 30 years, the new law is in effect because it covers existing structures. But I'll let Vicki address the other concerns you have.
With the example you used with the popping of the nails in the drywall, sometimes that may concern us because we have been in a dwelling unit where we may see an entire wall where the nails have popped. That may pose a concern to us as to maybe there is an issue, an underlying structural issue going on above it. So we may take that into consideration. So why it's in the checklist is, you know, we all know drywall nails pop out and screws pop out. It's a normal thing. It's a settling thing. But if you see a pattern of it, you may want to investigate that a little further. That's why that's in there.
If you've got 1 or 2 nail pops, we're not going to issue you.
Right.
Inspection isn't a little, you know, the people doing the inspections like yourself, it's brand new, and they just go list by list, and being a little overzealous, like, oh, yeah, nail pops, oh, probably window.
Yeah, this.
You know, I got $100,000 worth of repairs.
This checklist, I tried to make it comprehensive so that you could understand it. I work with this ordinance. I've done this for 20 years. So I know, you know, the ordinance, and sometimes it's not necessarily in layman's terms. So I tried to make this more in a layman's terms so you could kind of get an idea of what it is. So please note that, like Linda said earlier, we're not looking for your building to be the Hyatt Regency. We just want it to meet the minimum codes. A couple nail pops, hey, you know, that happens. But if there's a large pattern of it, that may be something that would cause you to want to investigate further. Next question.
Hi,
Yes, sir.
I'm a little nervous, so I have a question, and it's for the fire department.
Okay, Doug?
I have problems with tenants parking in an area that is, the fire department says it's a fire lane. She's already shaking her head. Thank you for helping me. Unfortunately, the fire department says the police department writes the tickets out.
Right.
Should I stop talking? You take over? I mean, I'm not trying to, I'm very nervous.
agreeing with you.
Okay, so the landlord will not put a sign out there saying it's fire lane so the police department can write a ticket. And he does not say that's part of our code. Is that going to be part of our code enforcement that comes through there? Because this is over too many cars. The landlord has a 2-bedroom apartment. He has 5 cars in that apartment. Obviously, too much parking. No street parking where I'm at. So there's a problem there. Is this going to be taken care of in the ordinance? Because I'm happy to give you the $120 as long as somebody puts a sign up for a fire lane and the police officer writes a ticket for that. Then the landlord gets put on there. You can only have so many cars in your parking lot, because that's where the problem comes in. I try to rent an apartment. I have 8 spots. I want to only have 8 cars there, not 9. I try to do that. It doesn't work out for other people. They have abandoned cars there. And I know I'm going to, everybody talks about this. That's my first question. My second question is, you say this is going to help us out get more money for our rent. I haven't raised my rent in 3 years. I made more money 10 years ago. You're requiring me to give you more money, give everybody more money out of my pocket, and I'm happy with all this stuff. I really am. But I'm making less money. It's coming out of my pocket now. And I'm making less money as we go along, and you're saying this is good for us. I don't see where it's going to be good for a landlord that's been in business for 20 years. You don't stay in business that long for 20 years and have a nice building.
Okay, let me address your first question. First of all, I'll defer to Doug. Doug, are the fire lanes supposed to be marked in a certain way?
If there are specific fire lanes and they are signed and you have an agreement with the police department that they can control it, then citations can be issued. There is no specific ordinance that designates fire lanes except around larger commercial buildings, hotels, large life loss. Around apartment complexes, we don't have a specific ordinance that designates fire lanes. So it's more of an agreement between us, the police, and the building department as to what can be designated as a fire lane.
Now, sir, do you wish to designate a certain area as no parking in your parking lot? Is that what you're saying?
So I've been in Westmont for 10 years, okay? I've been in other towns prior to that. And what I did is I bought a piece of property where the landlord continuously lets people rent there that has 4 or 5 cars, and they're only driving 3 of them, and the other ones sit there, take up, yes.
I'm confused.
Yes.
If you say you bought the property, are you the landlord?
Yeah.
Okay, so
Not of the other buildings, though. Mr. Daniels knows my building, he knows where I'm at, he knows the problems, he's been there, he knows what my problems are. And there's continuously junk all around the property, and for 10 years. So is this gonna help me get rid of those cars that are not on my property?
Do you have an agreement with the village for enforcing the signage on your property?
No.
You need one. In order for the police department to issue tickets for no parking in a fire lane, then you need to enter into an agreement with the village so that we will enforce your signs. That's under the vehicle code, basically. That we can have those kinds of arrangements, and then the police department can come and issue citations.
Okay, I went down to the police department several times, many times, and they did not inform me of this form. They just said there's nothing we can do about it because it's private property.
You have to go to the village administration.
Is Chief Mulhern here? Sorry to bring you in here, Chief, but I'm thinking maybe we'll just go right to the source to see if we're answering this question properly for you. This is
Make sure I'm
Police Chief
understanding your
Mulhern.
question. Is the problem is the property next to you, not your property?
Correct,
Okay.
yes.
And abandoned cars are on the property next to you, not your property? Okay. The problem with that is that if we have an agreement with you to come on your property, we can enforce the traffic laws and parking laws on your property. However, if your neighbor landlord does not have that agreement with us, we cannot. So your question was, will this help you? It's my understanding it will, because now the subjects, all the conditions that you're going to be subject to, he will as well. Now that's going to clean up the cars, it's going to clean up this, and as Linda explained earlier, that's going to be the benefit. It raises the property values, it raises the quality, it raises everything else, all these violations, so that should help you, because as we enforce this, not only will we be enforcing on your property, we'll be enforcing on his, that would solve the problem.
Okay, last question.
Yes, sir.
But is this a new rule that we're instating today at 2010?
Which?
The parking. Then why wasn't
No.
it taken care of prior to this?
The problem is, we don't know what the property, well, hang on a second, we don't know what the property owner next to you has done. We cannot go and force him into an agreement. As you came to us, you have to come to us and ask for the agreement. We can't go and make him have an agreement and enforce those. It's private property. We can't do that right now.
Sir,
I can do it on yours, but I
promise you-
can't do it on his.
We'll sit down with you individually. It sounds like a very specific problem that you have here. It's kind of a dispute with you and the other property owners in your complex. We'd be happy to sit down with you privately and try to work through the problem that you're experiencing.
Is it up to the other landlord whether he wants to get those cars out of there?
Yes.
Yes.
So it's not going to solve.
Well, see, we need more information about who owns the parking
Yeah.
lot. Do you own part of the parking lot with your building, or is it owned by a common area?
I own it all.
You own the entire parking lot?
Yes.
Well, then you control the parking. We'll sit down with.
My parking lot I control. I'm
Okay.
not trying to yell.
No.
Sure. We'll sit down with you privately to discuss that, because it's a very specific problem.
For 10 years that this has been going on, and if it's a new rule, then I want to see
We
the
could,
effects.
if we can.
January 1st, 2010, I want to see the new effect.
We will work with you individually, because it's a very specific problem relative to your specific situation.
Right. Okay, next question.
Who do I speak to? I don't want to take the time up now, but who do I speak to clarify if the property I own is, if the ordinance is applicable?
Just give me a call.
Okay, thanks.
Yeah,
Morning.
two things. Good morning. When does it, pretty soon, good afternoon. When does this have to be in the forms from the tenants? Into your office?
We talked about this at a staff level. We're going to be a little lenient on the crime-free lease addendums because of the time span here, and it's the first time it's being done. We would like to have the crime-free lease addendum signed in our office by, what time would we say?
4th, I think it is.
By the first week after January.
Number two, this fee or license, whatever you classify it as, are we going to get a bill every end of the year for the 180, or depends on how many apartments you have? Are you
Right.
going to send us a bill? to pay?
Invoices will be sent out at the end of each year, well in advance. And the clerk's office has an invoicing program that does that.
So you would send us a bill?
Yes, sir.
Not the first year.
Not right now, because
we'll pay
we're new.
But the
But
following year,
for the
210.
renewal, right, exactly. I
Do we
believe
get a
that's
license
correct,
for
right?
that?
Yes.
We get a license to post somewhere?
I believe that the program, and this is coming out of the clerk's office, but I believe that they do have an actual license that prints out and will get mailed to you.
Good.
This refers to the abandoned cars. Say, for example, in Pond, which is a common parking lot over there. How am I responsible for the car parked in the parking lot in the Pond area, for example?
Well, you have a managing agent there,
Yeah, but you're putting
Terry.
it my responsibility. It's a landlord responsibility.
Well, the common areas, I believe, are managed by the ponds themselves,
So who's
the
responsible?
association. And so you would need to just call the association and
Yeah, but
let them handle
in
it.
the ordinance, you say the landlord is the responsible party.
I'm sorry, I can't. I'm sorry, just a second. I'm sorry.
In the ordinance, you're saying it's a landlord's responsibility to get the car towed.
Right, but understand that the ponds has a different setup in that they have an association and their managing agent is on site and they have their own towing policy.
One more question. And the lighting illumination, that refers to when the light could be diffused by dirt and aging. So your illumination level, what does that refer to? It could be any illumination. Once the diffuser gets dirty, you have maybe half the light in there.
Then have the association clean it.
Well,
You're talking in the parking areas, correct?
that's what you're referring to in the
Sure.
parking lot.
You call the association and that takes care of that. I am assuming you pay association due?
Yeah.
Okay, and then if that's part of their responsibility, give them a call.
To kind of answer your question, the application, it's for a wide variety of landlords, okay? So in your particular situation, you'd have to contact your management, okay?
Good morning.
Good morning, how you doing? On the application, you said you wanted a contract from the towing agency and the fire agency, and some of us apartment owners, we have an association that handles it. Do you need a full copy of the contract, or do you just need contact?
First of all, we do not need a copy of your contract from your fire alarm system, okay? We would like a copy of the contract from the relocation system. In some of the units, the association takes care of that. You can just copy it and attach it to the application. Or what we're trying to work out, say with one of the complexes, is they've sent us a copy of it, and we've just made multiple copies and attached it to the application. We'll get to you there.
As a follow-up to the question, do the citation go to the association or just go to the landlord?
Yeah, that's going to depend on who owns the property, okay? So if it has to do with the building, and that's yours, and that's your responsibility, it will go to you. If it has to do with, say, the parking lot or the portion where the association is responsible for it, the violation will go to the association.
Okay. A few other questions. Can the application process be done online so that saves time for the landlord?
Unfortunately not, because you can't sign the application online. Download it, fill it in, and get it into our office. We are going to, as long as your application is postmarked
by December.
By December 31st, and it comes in obviously with the holidays, the mail's going to be slow. As long as it's postmarked by the 31st with the fee, we'll consider it submitted on time.
Okay. The crime-free form, should we submit after renewing the lease, or?
You should get that.
We can go to the tenant and ask him to sign something down in the middle of the lease.
You sure can. And you can go to them and tell them that there is an ordinance put into place, and now you must sign this. And that's what you can do. We've gotten an opinion from our village legal counsel that says, yes, you can go to that tenant and say, there is a new law in the village of Westmont. You now must sign this addendum.
So if we don't have a cooperative tenant, what should you do?
And take the necessary actions that you have to, either evict them or,
That's a lot of energy.
you know, we'll just have to take that on a case-by-case basis. The applications I've gotten in so far, I haven't seen any problems with that. And again, like I said, we're going to give you some leeway here because this is new. And obviously, upon renewal of the leases, you're going to have them sign that again.
The Ponds has a form very similar to this.
It's the exact same form.
It's very similar, may not be exact.
Yeah, it is exact. It's just that what they chose to do was have it copied in a two-part form because they want to keep a copy of that addendum in their personal files. It's the exact same form. Okay, let's move on here. We're getting to 10:30 and.
When they want to do inspection, it would help the landlord if they give exact timing. Let's say they do it on Monday at 10 o'clock. So
we're going to try, right.
I had experience with you last 2 years ago, and there was absolutely no cooperation as far as the village. They came and then they did the inspection and they sent me citation. I made many phone calls, wanted to meet you, and my phone calls were never returned. So eventually we had to go to court. I was really willing to come and meet you and show you what I did, what I have to do. And I never received any response. And I don't know, I hope.
We're going to do our best when we set up the appointment on the date to give you a specific time. It's very hard to give a specific time because it may take us longer in one building versus another one. So we're going to try and feel that out. We may say that. We're going to be there on a certain day between the hours of 9 and 11. So.
If you'd like to discuss it afterwards, we're going to be here afterwards.
Okay, next question.
First short question is, can we use just the apartment number for this crime-free lease addendum? In other words, if
yes,
I've got,
sir.
So I could put 5 tenants on there, just tell them that we need anyone that's 18 years of older in your apartment to sign this?
Correct. You can have one addendum per unit and just have everyone 18 or older in that unit sign that one form.
Okay.
And then put the unit number on it.
Then the other question is for the attorney. There's been much said about evictions, and of course, we've probably all done some of them. In the absence of a lease or with a monthly lease, we don't need any reason to ask someone to leave if we're the owner of the property.
Right.
Is that correct?
If it's an oral lease, it is considered by law a 30-day, month-to-month
Then
lease.
you just give them the 30-day notice.
You have to give them notice to get, and
because
that's it.
Yeah, by the time someone gets convicted of Class X felony or misdemeanor,
Absolutely.
the onus would be put
You
on us.
don't have to wait till they get convicted. The grand jury indictment is enough.
Right.
But
I mean,
you're right. If
by
it's
the
a month,
time, the onus is on us to do all that. So
Yeah.
if we don't have a lease, we just ask them to
If it's a month-to-month lease, you have every right
Okay.
to terminate it.
Thank you.
You're not going to need to do your jogging today.
I just wanted to get to some of the other people there.
Sorry.
Okay.
On the trust, I have a trust, but I believe my name is only on it, and it's transfer on death to my kids.
Right.
And do I have to have their names?
No. If it would be whoever the current beneficiary is, the current beneficiary, which if you have a living trust, that would probably be you, and your children would not be involved in it until such time as they were to take possession. Right, okay. You have a land trust. The names of the beneficiaries. No. If you have a land trust where you are the beneficiary during your life, then you're the only person that needs to put down who the beneficiary is. It's just that, see, with the land trust like you have, it's only the name of the bank that shows up in the public records, and for purposes of sending the notices, they'll ignore the notices, and so we want to make sure it gets to you, so we need to know who the current beneficiaries are. Some trusts only have one beneficiary, some of them have more than one person, and we just need to know who that is so that the paperwork gets to the right person. They may be involved in taking care of the building, and you may designate them as a managing agent, but unless they are currently a beneficiary of the trust, you wouldn't put their name down as owners.
Yes, sir.
I just want to ask if the village really understands as, landlords, we're not minting money, okay? When you do the inspection, turn out like around 50 or 60 items listed in there. But if you look at the building, like the building that we own, it was quite good. Okay, we inherited this when we bought it. And with good intention, we tried to upgrade it, but it cost a lot of money. I just want, wish the village understand that this cost a lot of money. And we really want to upgrade our units. And I looked other places. Ours is good. And, but does the village know that this cost a lot of money, and these are not really garbage places. They're reasonable places for people to live who are making less money. As landlords, we provided this for the people. We're not making a lot of money out of this.
We understand.
Okay, we completely understand that. And again, the inspections, the property maintenance code are minimum codes and for the life, safety, and welfare of the residents and tenants that live in the building. That's what we're looking for. Yes, ma'am.
You addressed that gentleman asked the question I wanted to ask, but I just want to expound upon it. You said you encourage people to be there, the landlords to be there when the inspections take place. Is that correct? And that's wonderful because sometimes I don't understand what you're talking about. When
Exactly. And it's worked out very well in the past.
Yeah, the problem is, though, most of us don't live in the buildings, so, a little tight window would be nice, or a call to say we'll be delayed or we're on the way would be very helpful to us to meet the inspector there.
Right. We're going to have all of your information now. Okay, prior to this ordinance, we didn't have any information or correct information, so we'll have that with us.
But a call would be nice to say, we're on our way, meet us there. Or
right.
We'll be there between 9 and 11.
That's what we're going to try and work out, yes. Yes. Wait, who has not asked a question yet? Okay, can we get to them first and then get back to the people who have already asked questions? That way we can move on. Can we just pass it down here and then come up around here? Yes, sir.
Yes. Do we have to have the crime-free addendum signed for all existing tenants as well as all new tenants?
Yes.
Okay. And you're having a little latitude in getting those to you, right? Sometime in January.
Yes, sir.
Second question, as to the responsibility of getting the application completed. I deal with owners who have neither fax nor email capability. Okay, it's already December 5th. We have not taken any action to get this out. If I get these applications in during the month of January, will that be sufficient? Will you accept that?
We will accept them, but you may be subject to the penalty.
Okay.
It's 20% per month of the fee.
And the last question, give me an example of Class X felonies, please.
Oh,
sure.
The expert.
Aggravated criminal sexual assault, possession of a certain amount of drugs like heroin or cocaine. Distribution. Armed robbery. I'm trying to think of some of the aggravated hijacking, murder. I mean, it's real serious offenses, which is why the other statute that only lets you do it for Class A misdemeanors is a lot more user-friendly.
Yes, sir.
If you already have a crime-free lease addendum in place that is not verbatim to yours, but similar in nature and covers all the same points, and is already signed and in my file cabinet, can I make photocopies of those and turn those in, or do I need your specific form?
That would be fine as long as the same information that we have in ours is in yours. You may add additional language if you wish.
As you take on new tenants during the course of the year, is it appropriate to turn in all new lease addendums on January 1st when you renew your, what do you call this thing? License? Or as you take on a tenant, run to City Hall and turn it in?
Yes, sir, that would be correct. If you get a new tenant, say you rent out another unit, you're going to make them sign that at that time, and then you would send that into the village.
Last one, upon lease renewal, if it's the same tenant, they're renewing, they signed one originally, do they need to sign another upon renewal? Crime-free lease addendum.
Right.
You'll have one
If
on
you
file.
transfer that addendum to the new lease, it would still be current. That's going to be totally up to you. If you choose to have them sign another one with the new lease, that's going to be up to you.
Gotcha. So in other words, the village doesn't require another one if it's the same tenant occupying the same unit?
That's correct. But just when you do renew, though, make sure that you send a copy of that with your application each year with your renewal.
It's my understanding that the Department of Housing and Urban Development developed that lease addendum as part of the whole crime-free housing program. And so almost every single lease addendum that you come across is very, very similar to that one because it all originates from the federal government.
And I'm assuming that's why it's will suffice.
I had a very similar question, and I have DuPage Housing Section 8 tenants who already have crime-free documents. Should I go back and have them sign this again, or no?
No, just a copy of what they have because it's the exact same thing.
And that raises a point. If you do have tenants that are in violation of the requirements of that lease, by all means, we want to work closely with DuPage Housing to help you get rid of those people that are a problem, because we'll be doing, I know they do some inspections, but we'll have the inspections, and what I have found is that when we tell them, look, this is the condition that we found it in, and if it's the tenant's issue, that will help you end that relationship.
Yes, sir.
Just expanding on what they said, you know, with the crime-free lease addendum, I have them on my leases. It's not this one, obviously. I haven't sat down and compared them side by side. To the extent they're not identical, it's hard for me to, because in effect, I'm breaking their lease, having them sign something different. So
No, you're not breaking.
You're not breaking their lease. You're just asking them to sign a separate.
But why would they sign it mid-lease? I'm playing devil's advocate.
Because a new law has been enacted that's effective immediately.
Okay.
Yes.
Right, so as a resident of Westmont, they have the responsibility to abide by that regulation, so.
Okay. So I guess then back to his question, if I already have it, but it's not this, can I hand that in and then you'll tell me whether it's acceptable or not, or how's that? Okay.
That's fine, as long as it has the same,
kind of,
the same information in it. Some of them might have it, some leases are 10, 15 pages long. You may not want us to send in that whole lease, so you may just want to say, hey, look, this is already in your lease, just sign this, so I only have to send in one sheet of paper.
The key is, in order to enforce the Class X, you have to have a crime-free addendum. And as long as your lease matches that, we're going to be satisfied because that's the purpose of it.
Right.
Okay?
Wouldn't the Class A cover anything that the Class X?
You're right, it doesn't, and it doesn't require a crime-free housing addendum, so. Exactly.
Right. But usually these addendums have some language at the end that says, and, you know, not all inclusive, or that sort of gives you enough leeway.
It's just, it's a nice heads up to your tenants that we're not going to, you know, if you commit crimes on here, this is going to be a problem for you. That's the major effect.
I'm sorry, one more question. I'm on the board on one of the associations, and to the extent that the application requires the towing and the fire information, and more for consistency to throw the fire into it, but more for the towing aspect, we would rather, I don't know if it's acceptable, but could we just, as the association, hand in those contracts under the association name and direct the owners in the application to say, you know, see Willow West file? And the reason why I'm saying that is because the last thing we'd want to do is give all this contract information to the owners, and the owners engage in some towing war that takes the towing aspect completely out of the control from the association. Now you're creating havoc. So not to not provide it, but it would make sense for the owners to say.
The association handles that. Yeah, in your particular case, the association is handling the towing policy.
Right.
So yes, I believe that we decided at the last informational meeting, and after that we would take one copy and then we would attach it to because you have multiple owners.
Right.
That we would attach that to that.
Okay. Thank you.
Yes, ma'am.
I have two questions.
Okay.
The first one concerns the parking lot related to what that gentleman was talking about. In our complex, two buildings share one parking lot. We each have a side with the driveway. We don't even own half the driveway. We own a third of the driveway. The other owner owns a third, and the middle part is the easement. And we continually have a problem with the other owner parking, sometimes 12 cars in an 8-car spot.
Okay,
So,
like we said before, it sounds like an individual issue that maybe we need to talk about it further in detail.
Right.
Okay.
And it also blocks the way, but we also cannot get him, like, we need to replace the driveway. Well, he won't agree to do the driveway. So if you're going to write a citation about the driveway being torn up, we're trying to fix our part, but we can't just do a third of it. We have to do the whole driveway. So
Understandable.
will the village be able to work with us to get the other one?
Most definitely.
And my second question concerned the license. Since we're an LLC, are you going to put the LLC on there? Because I really don't want my name on a public document.
We need the names.
Right, I know you need my name, but on the license, I would prefer that the LLC be on the license.
Yeah, the license will always be in the name of the entity that owns the property, whatever that is.
Beck.
My leases come up like January through March. And to go through the hassle to have them, or I know I'm going to get a refusal on having one of them sign the crime-free lease addendum. A lot of that's in my lease already. However, what problems would I incur if I just sign them or get them signed at lease renewal?
Are you going to renew this person's lease?
Probably. He pays the rent on time.
Okay, and he refuses to sign that.
Yeah, let's say he does.
It's your responsibility to make sure that that crime-free lease addendum is
I
signed
can't
by
force
each tenant.
him. I can't force him.
Then you can't rent to him.
Oh, but it takes me 3 months to do it.
Okay?
Okay.
Our ordinance requires, that you can show him that ordinance, and if
Yeah,
there's more
yes,
of a
yes,
problem,
yes, yes.
we can deal with that tenant on an individual basis.
But let's say, what problems would I incur if I just have them sign it at lease renewal? If they don't sign it at lease renewal, bye. And it's 3 months. In March is when all of them come up for renewal.
That would be
January,
acceptable.
February through March.
That would be acceptable.
Okay.
Yeah.
In the back here.
We recognize that some of you are going to have problems with some tenants that don't want to do what the ordinance requires, and then it's up to you whether you, because the problem is, it's not the tenant that's going to have a problem with the ordinance. They're not the ones that are subject to not having the license renewed. You're subject to not having the license renewed, so it's up to you to decide whether you want to renew their lease or not, understanding the consequences that could happen if you can't fill out an application that can be granted.
They have grounds to break the lease.
Yeah.
Right. It's a
tenant has grounds to break the lease. A condition has been put on their residency that they did not initially enter into upon lease signing. So now they could take the lease, rip up, and walk away.
I doubt it.
I think there's a difference between changing the terms of the lease and having to have a paper sign required under an ordinance by the Village of Westmont.
Yes, sir.
Yeah, hi, Nikki. I have a question regarding what you just mentioned about the property damage. You mentioned that if the property damage above like $150, then it will rise to the forcible entry.
No. What I'm talking about is if there is, if someone commits the crime of criminal damage to property, not just damage to property, but knowingly without lawful authority damages property, your property. If they knowingly and without authority damage your property, that's a crime, and if it's been reported to the police and and a charge has been brought, that would be a basis, because that would be a Class A misdemeanor if someone, let's say someone punched a hole in the wall. That's criminal damage to property. That would be a basis for you to be able to use to evict them.
Right, but if I have an inspection, say if I walk inside an apartment and I see there's a hole,
right,
how do I prove that this is a criminal enforced punch?
Sometimes you have to talk to people, and sometimes people will tell you the truth, and sometimes they will lie. I mean, that's always a problem for the police in terms of trying to prove those kinds of cases. I understand that.
So in other words, you need to have a police approved in order to do that.
Well, you would want to have the police investigate that, and somebody might admit, I mean, the wife might say, well, he got drunk that day and punched a hole in the wall, and then that would be sufficient to show that that was the person that did it.
Yes, maybe I'm not hearing it or understanding that crime-free addendum. Do you need copies of that with our application?
Yes.
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 Okay, but not copies of the lease, just the crime-free addendums need to be sent in with the application?
Right.
Yes. Okay, thank you.
Right, because that helps us. It helps the police know who's supposed to be on the property and who's not, so that if you have someone that you want to bar from the property because they're a friend of one of these people and they're a troublemaker, and you want to issue a no trespass notice, and you want to let the police know that, so that if that person comes back on the property, the police have the ability to arrest that person, okay? And if they're saying that, well, I do live here, and the crime-free housing addendum shows that they do not, then that will assist the police in helping you out with a problem person that is causing problems on the property and not even paying you rent.
Can you explain the protections for owners under FOIA again, keeping their identity private?
We had concerns where the landlord said, you know, this is public information. Someone comes in and says, I want to see the names and addresses of the owners of my building, okay? There were concerns that we would give that information out. Under the new FOIA Act information, we can no longer give out personal addresses if there isn't, I don't know the right terms, if there's no public intent or public use for that information.
Well, I think by the same logic,
you know where that's referenced?
Excuse me. By the same logic that the police department can redact the addresses and phone numbers and email addresses of an arrestee, we can redact your address and phone number and email information from a FOIA request that we respond to. We may have to give them your name, but we don't have to give them your address and your phone number and your email address.
Right. That's individual personal
so
information.
Do we need to request that, or?
Pardon me?
Do we need to request that?
No.
No.
No, we will deny a FOIA request that asks for that contact information.
Right. And we have.
And when asked for ownership, will you give the trust number as the owner of record, or?
I think you have to give the name and
the name of the trust.
Yeah.
So however it's
what's a public
recorded in
record?
the county record.
Yes. Yes.
So if on your application the owner is trust number 1234, that's what will come out. Okay. Other questions? Over here? We'll get to you over here, I promise. Yes, sir.
Excuse me, one more. How do I keep apprised of all the Class X felonies and all that stuff?
Yeah, as I mentioned earlier, we suggest that every month you go into the police department and fill out a Freedom of Information form for your building and ask for the calls for service. In other words, you know, how many times the police have been there. I believe, and Detective Gavrileski can correct me, it may not show you the names or anything like that, but it will tell you what the call of service was for and the disposition of that. Yes.
And all that too?
I'll let Detective Gavrileski answer that.
You're gonna have to go on your own and figure that out, okay? The only thing we'll give you is call for services. As far as you finding out what the criminal history's like, that's something that you need to investigate on your own, do backgrounds and stuff like that.
But you can run at DuPageCase.com. You can put in names of individuals and see what kind of cases they have pending in the court system.
In DuPage.
In DuPage County. DuPage Case. No, you go www.dupagecase.com. For some offenses, you're able to find out online if someone has various offenses. And you know, and the newspaper prints names of offenders all the time. I mean, that actually is public information.
My concern is I'm going to mishap that stuff by being at the courthouse, by being at the police station, yada, yada, yada. How do I keep apprised? Is there an automatic service or something that sends me stuff related to my building?
No.
If you're a law enforcement officer, other than that, I mean,
Yeah.
other than that, you know.
That's why we encourage you, you know, once a month go in and put in an Information Act form, and you can at least know what's going on in your building. Okay, hold on just a second. What was your question, sir?
Give him the microphone.
Some of the information that Linda was talking about on different people is online at
DuPageCase.com. I know that they have the traffic and ordinance violation information online in terms of, you look it up by name and see all the different charges that are pending against a particular individual. It even lists their date of birth. in some circumstances. You can see if there's a case pending. Ultimately, you can go to the courthouse, and they have a computer system that allows you to index any case, whether they're being sued or have been sued, whether they have any felonies pending, but you could get that information at the courthouse, at a computer terminal.
That's in Wheaton?
In Wheaton.
That's the only one in Wheaton.
At the main courthouse, though,
Right.
I know you can get felony information at the main courthouse in Wheaton. I'm not sure how extensive the database is online at DuPageCase.com. I know it has traffic and ordinance violations. I don't know if it has CM or CF cases, but you could run the name through and see what pops up.
You just need the name, you need.
Just the name.
Yep, just
now, there
enter
might
in.
be, 35 John Smith, so you have to know the date of birth or the middle initial or something, but gives you a start.
Are you the legal person here? If we need.
I'm the village prosecutor. There's also a village attorney, and the village attorney. No, I'm not here. I handle things when it gets to the court stage.
Can I ask your name, please?
Linda's? Oh, mine, Vicky Sunnysack. SENESAC, Code Enforcement Officer. And all of my information is on the website. This is Fred Kimball. He is our Economic Development Director. I apologize for not introducing. Is Doug still here? Doug Daniels, the Director of the Fire Prevention Bureau.
Who's this guy?
And this guy here is Detective Leonard Gabrielski. He's also what we call a POP detective, a problem-oriented policing detective who assists me a lot. Yes, sir.
If we have any question during filling this permit or license, who we call?
Me. Call me. 630-981-6262. And again, my name and number is on the website. Yes, sir.
On two of the videos where you showed the provisions for the Class X and Class A eviction process, it was notated that the tenant does not forfeit their
security deposit.
I'm assuming what you meant on that line was that for the unpaid portion of rent provision.
Yeah, if
there's
you have
criminal damage going,
you can evict people on 3 different grounds. It is only under that provision if you were only to try to evict them to declare it void because of a crime, then they would get their security deposit back because you wouldn't be evicting them for failure to pay the rent. If you're evicting them for both reasons, then that separate failure to pay rent would go into effect, and then that wouldn't cancel that out.
well, and as well as any damage to the.
Exactly. Yeah. Yeah.
It was a little misleading on the.
Well, it's what the statute says, so.
I'm in the process, right now my building's in a trust, land trust, but it's in process through Wheaton to move to a different entity. When I fill out this application, the beneficiaries are the same, but which do I put?
Well, here's the problem, is if you transfer it from one trust to another, you're going to need a new application because it's a new entity.
Okay.
If you notice in the
Right.
ordinance, you can't transfer, that the license is not transferable.
But the beneficiaries are the same.
Well, I think we could review that on an individual basis because a trust is a little tricky.
Right.
And if the beneficiaries are going to remain the same and only the trustee is going to change.
Yeah, it's only the entity name.
Then basically you'd need to let us know that so that we can just correct our paperwork because ultimately the ultimate ownership really wouldn't change.
Right.
So
But when
that's
I-
kind of an unusual situation.
But when I fill out the application, I haven't received anything from DuPage County that says
Should
the
send
new
an
entity's
amended
been
application.
recorded, so which do I fill it out
Yeah,
by?
just put in the current information, and then when you get the new information, send an amended application with the new information on it.
Okay, because I don't want you to deny it if all of a sudden I get caught in the middle when
Right.
you're looking up the parcel number and you're like,
Right, that there's been a transfer. Yeah, that's something that you should all be aware about. When there are code violations found on a property, it's a violation to transfer the property unless the new buyer or the new entity coming in signs a piece of paper, a sworn affidavit saying that they understand there's problems on the property and agree to correct them, and we receive a copy. So just be aware that if you're in the process of selling your building, and you've received a notice of violation, that new party we have to know that they're aware of it, and we have to get a copy of their agreement to correct the problems.
Yes, sir.
With this ordinance, you're just
singling out 3 flats and more. Why wouldn't this affect 2 flats and any home in the village where these people can do the same thing that they're doing in an apartment building?
It may in the future.
Right.
Yeah, I'm going to let the attorney answer that because of case law.
Normally, we start with larger buildings to see if the manpower that we have can just cover that. We also sometimes, it's a question of looking at where the major problems come from in terms of the amount of where the crime is in a city. I'm not just talking about Westmont, I'm talking about anywhere. And what you try to do is use the manpower that you have, or the people power that you have, to address the entities that are going to result in the biggest benefit. Sometimes then the ordinance will be amended to include those other ones, but we can't start with the smaller ones first because that would be a violation, that would be unconstitutional, because it's recognized that there are more people at risk that live in a multifamily building in terms of health and safety when there's a problem on the property than in a single family home. And so we have to start with the bigger problems first and deal with it. So Westmont made the decision to start with 3 flats and see and let's see how that plays out. We can revisit those other issues later, especially if we see that there are some problems. There are some cities, especially that have a huge college population, where you definitely want to include single-family homes and duplexes because that's where the problems are. Typically, that's not true of a town where it's a non-college-based town, where it's just mainly most of the bigger problems are with the multifamily buildings. And so that's just kind of the logic of why you do it that way. And that doesn't mean that someday we won't get to that, but first we have to see if we can deal with the amount of apartment buildings with the size of the staff we have. And so it's really an allocation of resources that sort of decides that up front, and then we'll see what happens.
With these inspections and that, those kind of things that you're going to find in these buildings, you'll find in anybody's home. Probably even your home wouldn't pass this inspection.
Well, actually, my code inspector in the town I live in says mine does, but certainly, but the problem is see, what we're trying to do is we're trying to address the largest threat to the largest population. And if my house burns down, it's really bad for myself and my husband. There's 2 of us. But if an apartment complex catches on fire because of issues, or it collapses, or there's a water flooding problem, it's going to affect a lot more people than just the individuals. And I've got control over my property as a homeowner. Tenants don't have as much control over the living space they're in as a privately owned individual does. So that's kind of how that evolves. It's not that we don't have problems, just that the risk to the public is not as great as if it's in a larger building.
Okay, we'll take maybe one more question. We've gone a little farther than I really wanted to. I know everybody's got a lot of things to do, so do we have any more questions that haven't been addressed yet? Yes, sir.
Okay, I didn't get a vote on this ordinance being passed, or nobody around here, the landlords, we didn't get a vote as to passing this thing, and it's like shoved down our throats. It seems like a good thing, okay? I see nothing negative about it, except I hope that you can be lenient when it comes to these repairs. Like the gentleman back here said earlier, it can be very costly, and we're not making a lot of money on our units. And it's like another tax to us now to put upon us. And since we didn't get a vote on this ordinance passing, are we going to have any say-so when the fees when you decide $30 isn't enough, now all of a sudden it's $90? See, I'm getting I'm fed up with the state of Illinois raising my license plate tax for a little sticker. Used to be $38, now it's $98. That's going to be $98. Whatever. Yeah, you're getting less and less and less, and we're being taxed. These villages, they can't get enough money because the businesses are moving away and this and that. The car dealerships aren't selling cars. You know, I hope that you can do something for us if these fees are going to go up. Maybe give us a vote in the matter somewhere.
Well, sir, this ordinance was passed following 3 public hearings by the Westmont Village Board, and then they appointed a subcommittee that consisted of village staff members and attorneys representing the interest of landlords and attorneys representing the interest of tenants. They studied this ordinance for 9 months and made a final recommendation to the village board. The village board went back and in public session made several other changes to that ordinance. This all took about 2.5 years from start to finish. So this isn't something that we just jumped in and said, we're going to pass an ordinance and it's $30 a unit. That went with about 2.5 years of study and including the wishes of landlord attorneys and tenant attorneys as a part of those discussions. So we're very understanding of what you're saying. These are very difficult economic times for us all, and the business of renting property is under duress just as the business of selling cars or the business of operating a local government. So we're sympathetic to your
I found out about this meeting from a tenant. I didn't even know about this stuff, okay? And now all this stuff is putting me upon me. I didn't even get the applications. My computer's down. I need the paperwork from you. I can't download this. I hope you have it here for me today.
We can get it for you.
Thank you.
Can you explain, Fred, how we came about the $30?
Well, the $30, we said, okay, knowing that we're going to have to employ some building inspectors and some clerical people to administer this program, what percentage of their time are they going to be spending on this program? And I think the total calculation and the cost of a software program to track this so that we know when the inspections are supposed to be done and to properly record and document the results was going to be about from $9,000 to $11,000 per year. Then the cost of the salaries for the people that are going to actually be doing the physical inspections, the total cost for that program was about $140,000. Now, if you take an estimated number of rental units that fall under the definition of this ordinance, we think it's in the 4,600 to 4,500 range. If you divide that $140,000 by the number of units, it came out to, I think it was like $31.29 per year per unit. We lowered that and rounded off to the lower amount, which was $30.
I can understand that there was a lot of study going on with this, okay? They put a library up, okay? And they put it on our tax bill to pay for this library here. A lot of people don't use the library. I don't use the library. I live in another village than Westmont now. I got my own library, but I'm paying for this library, okay? Why didn't they just put it on the general fund and make it, since it's going to benefit the whole town, and benefit the whole area, why didn't they do it with the library and just put it on, instead of putting the bill on us? Why didn't they put it on everybody?
That's
as
a
long as
subject
it's going to benefit everybody.
That's a subject for a whole different discussion. That doesn't really have a whole lot to do with the ordinance that's before us today.
Do we have any other questions? Yes, sir.
I got a question about eviction, you know.
About what, sir?
It's so hard to throw people out the door out of the apartment when they're giving you a product. I went through that thing 2 years ago. I lost 2 months of the rent, which is $1,600. Then I have to go to the court. I pay my attorney, which was $900, like $70 altogether. And definitely the lady motion would be that she move out next day. No one paid my money back. And the judge asked the lady, are you happy? Are you satisfied with that? What you negotiated with the tenant? With the landlord? She says, yes. The judge didn't ask me one word. How much did you cost? How soon you could rent it? What damage did you get to that thing? Because supposedly her boyfriend was at, well, I don't want to name it, what was happening. And I went through that stuff like that. And we should have some kind of law so we could do it faster than that, I would say.
Yeah,
Can we do anything about it at the village?
you have to contact your state rep and your state senator to change the law.
If you don't mind, you know.
No, I don't know.
Because all the answer we were given pretty close, you know, but the thing is,
You have to contact your state rep and your state your state senator to get a change in Illinois law, because it's the state law that controls evictions. The Village of Westmont does not, state law does, and that's who you have to contact.
Thank you, Tom.
Try to get it violation or problem some other time.
Thanks, but no.
I think I do have a problem.
Yeah, that's one of the downsides of being in this business. That's definitely true.
Okay, oh, you got one more? Go ahead.
I want to piggyback off that question, but we can do it separately.
Nobody mentioned that?
Okay. I'd like to thank everybody for coming. I appreciate it. Again, give me a call if you have any questions.
knew you as soon as you came in.
Okay.